Hey guys, and welcome to today's video. Today we have a couple of sovereign citizens in court to cover. The first is a Soptardian Karen who really wants to regurgitate her half-eaten crayons all over the court record. And while the judge lets her do it, she clearly isn't paying any attention to her. And then the second is a sovereign citizen who thinks the court is trying to get him under its jurisdiction while sitting in a jail cell. So let's begin.
All right. Court is calling People versus Brendan Troutman in 25 CR 2239. If I can have appearances.
Holly speaks for the people.
And Brendan Troutman in proprio persona, all rights reserved.
All right. Ms. Troutman, last time we were here, you had informed the court you were still seeking counsel and you did not get the application for public defender's office even after the record was made, if there was any changes to your finances. So how are you proceeding today?
Well, I'm forced to be going to trial on this, I guess, if this is the last arraignment. I do not have the funds to secure private counsel.
For the record, did you inquire the public defender's office again after your last arraignment?
Yes, my income hasn't changed. I've moved my budget around to accommodate a small savings amount to secure a private attorney. But yeah, so I'm getting retainer fees of $2,500, $5,000, and $15,000. So that's just
so
not.
just for my clarification, you still don't qualify for the public defender's office?
I
Is
do
that what
not.
you're letting me know. Okay.
Yes.
All right. Ms. Spees, any additional record for the people?
Judge, I believe at this point, Ms. Troutman and I have had a phone conversation, a few conversations before court on different dates. And so given that I believe we've given ample opportunity to apply for the public defender, we should proceed forward with setting trial dates. I did just want to make a Lafleur record, and I don't have in my notes that an Arguello advisement was done, so I'm not sure how this court would like that.
I advised her last hearing, Ms. Spees, right? I believe Ms. Davis was covering for you.
Thank you for letting me know. In terms of the Lafleur record, right now, as the charges currently stand, the defendant has been charged with 5 counts. Count 1 is F for assault in the second degree strangulation, and count 2 is F for kidnapping, seize, carry. Count 3 and 4 and 5 are all misdemeanor counts. Count 3 is assault in the third degree, and count 4 and 5 are misdemeanor 1 or child abuse, and count 5 is misdemeanor 2, child abuse. I met with Ms. Troutman in the disposition room before court today and inquired if she wanted an offer. She said no, she did not want an offer and she would proceed to trial. Given that, I just wanted to put on the record that if Ms. Troutman wanted an offer, what we have VRA compliance for is M1 assault in the third degree and M1 child abuse for a dismissal of all felony counts and the remaining misdemeanor count with an agreement to probation.
Thank you for that. Do you understand that that would be the offer if you were interested in hearing an offer from the district attorney's office, Ms. Troutman?
Yes, I heard what she said. And I do get that that would be the offer she would be extending to me should I choose.
Okay. And are you accepting that offer today?
No, I am not.
All right. The court will enter a not guilty plea. We will set this for a pretrial conference. I'm going to set this on my next docket day of May 26th. Ms. Spees, is that clear for you?
May I have one moment, Your Honor?
Sure.
I also have 2 things that I need to put on the record.
Okay, hold on
As
just a
well.
moment.
Did you say May, Your Honor?
I did. In 2 weeks?
May 26th.
Mhm.
Yes, I can accept that.
Okay. All right, that's in 2 weeks. Ms. Troutman, morning or afternoon?
Afternoon will work. You're saying, is this pretrial? What is this?
Pretrial conference is when you clear dates for motions, hearing, and a jury trial.
Okay.
Speedy trial will run from today as I have entered a not guilty plea on your behalf. Speedy trial 6 months. We will set motions, jury trial, as well as a plea cutoff within that time.
So I do want to put for the record, I have to request an ADA advocate for this because I am not formally trained in law, that puts me at a huge disability with moving forward with this case.
You not being able to afford an attorney to handle your kidnapping and strangulation of a child is not a disability and would not qualify you for any ADA accommodations. What you should have said was that you're only working with 2 functioning brain cells, and that might have earned you some accommodations at a superglue buffet.
At pretrial, do I have to, is that when I would have to have all motions for suppression and stuff in?
No, that's when I set the motions date,
Okay.
and those would be due 30 days prior to the motions hearing.
Okay. Also, am I allowed to put what I need to put on the record right now? Or do you want me to wait?
Go ahead.
Okay, I just want to draw attention to my notice of intent for seeking redress, my right to redress, actually. For the record, God-given right for motherhood was violated, amendment violations, compelled being a witness against myself, clear evidence of investigation practices operating from a presumption of guilt, abuse of process, judicial misconduct, prosecutorial misconduct, trespass, assault and batter, and wrongful imprisonment. And I will be seeking redress in accordance with the Supreme Court ruling Trezevant versus City of Tampa, and the fee schedule that is currently on record with the Denver County Clerk of Record. In accordance with 42 USC 1983, 18 USC 241, and 18 USC 242. Notice is given.
All right, pretrial is set in 2 weeks. You're indicating afternoon setting. I can do a 2:30 if that clears with Ms. Spies.
Judge, I am in a motions and status conference at 1 o'clock in Division 500. We've already had a motions hearing, so I don't think it would take too long. But I fear if it goes past an hour and a half, then I may make this court late.
How about I do an 11 a.m.? Can you do an 11 a.m.?
11, yeah, that would work.
I can accept that. Thank
Okay.
you.
All right, Ms. Troutman, I will see you back on May 26th in this courtroom at 11 a.m. for a pretrial conference. The parties I do provide dates for jury trials and motions if you can clear that before I call the case.
Yes, Judge.
All right,
Okay.
we'll be in recess.
Okay, so that's the end of the first hearing. She had an appearance scheduled for last week, but either it got rescheduled or they handled it out of court because they didn't call her name on that docket. Now we head to our next __ who has 3 hearings to cover, with the first one taking place while he's in custody.
Mr. Locke, is that you? I can't hear you or see you, but I
Yes.
guess that
Yes,
is you.
Your Honor.
Okay,
Can you hear me?
I can. Is there a button for you to be able
Says
to
start my
push?
video. Should I hit that?
Yes, please hit that.
Okay, there we go. All right, now I see myself.
Okay, I swear that you were put on this I might have to refresh.
GF.
Yeah, I can't pull it up on my computer. Oh, there we go. Okay. There we go. All right. We'll go on the record in the matter 26 GF89, group file of Ryan Locke. Appearances are, we have the Assistant District Attorney appearing by video conferencing. We have Mr. Locke appearing by video with approval of in custody in Burnett County Jail. Mr. Locke was arrested a couple days ago. Bail was set at $500 cash with certain conditions. And then, Mr. Locke, I received your letter here today requesting that the court consider lowering that to $250. And in that letter, you say that you promise you'll do, you say, I promise that I will do right. You won't see me back here except for court. And so you're pleading with the court to lower that and to trust you that you're going to make your court appearances and engage in this process. Is that correct?
Yes, Your Honor. See, I've never missed court ever, and I had a I had an interview today for a job that is in walking distance from where I'm living in Spooner, and I was not able to make that today, but I was hoping to get out so that I was able to call them today back and say, hey, I'm sorry about the communication, but I'm very, very interested in that job. Is there a chance that I can still get it? Because I've been looking for work and it's been tough.
I hear you, Mr. Locke, and I don't want to interfere with your ability to get a job and to be able
Yes.
to provide for yourself, et cetera, because everybody deserves to do that and you should be able to do that. And you said it's within walking distance from your address?
Yes, it is.
So what is your address then?
It is 613 Smith Street in Spooner.
Okay. And is this a bar or restaurant or anything that I would have to worry about with bond conditions?
No. It is for a warehouse. It's tenant, TENT or something, TENENT or something. It's spelled.
Okay,
So I'm
all right.
really hoping that I get that job because I mean it's perfect for me. It's like right down the road. I mean there's no reason why I can't make the job because it's walking distance and then I'll be able to figure out my license and everything. So, but right now I don't have any money and that's why I didn't know that there could be because I mean Wisconsin is so different than it is in Minnesota because you have to in Minnesota you got to find like a bail bondsman. See, I didn't know that there could be a signature bond to where you don't have to pay anything to get out. So that would be awesome if I wouldn't have to pay anything because I can't even afford anything right now. That's why I was hoping to get a job so that I was able to.
Well, Mr. Locke, the reason why the court put cash on as bail in this
Yes.
case is because you have the open Polk County case. And in this new incident, that would be allegations that you violated your conditions of the Polk County bail.
Yes.
So then that raises concern for this court that are you going to make your court appearances? Are you going to follow the court's conditions, et cetera? So are you telling me here today that you're promising in open court here, you're going to, if charges are filed, you're going to abide by that and you're going to come to court? And I may allow Zoom too, because especially if you don't have a driver's license, I
Yes.
don't want you to drive if you don't have a license. And quite honestly, I want you to get your driver's license.
Thank you.
And I want to give you time to do that if that's something that we're
Thank
going to
you.
deal with in my case. And so I
Yes.
will do that. I'll let you know that.
Thank you.
So if you're telling the court and you are telling me the truth,
Yes, I promise.
okay, then what I will do is because I don't want to stand in the way of a job and getting a driver's license, et cetera. Well,
Thank
first,
you so
can the
much.
does the state want to make any statement, any argument?
State has no position on this, Your Honor.
Okay, so I'm going to believe you here.
Thank
Okay,
you
Mr.
so
Locke?
much.
And I'm going to trust you. And I'm
Yep.
going to tell you, if I extend trust and you violate it, then I'm not as nicey, okay?
I appreciate it so much.
So I will amend to a signature bond. You don't have to
Thank
come
you.
up with any cash because I'd rather have you save that. Even you said $250. I'd rather have you save that and work towards your driver's license, rent, food, whatever. So it'll be a signature bond and you just have to follow the conditions of your Polk County case and make your court appearances here and don't commit any other crimes or do those things that are written on your bond, okay?
Yes, I promise you. Thank
All
you so
right,
much.
Okay, so now we have your address and did I ask for a telephone number? Yes, I did. I think, did I?
Is it 763 4394?
4394 763. Let me see, 4394.
Correct.
Yep. We have that. We're good to go.
Okay.
Okay, Mr. Locke, thank you. Let me see, you are currently set right now for May 2nd.
May 2nd? I thought it was the 6th.
Oh, sorry, you're right, May 6th.
Okay.
See, you're smart, you're paying attention. I'm glad to hear that. May 6th at 2, May 6th at 2. And I'm gonna tell you, because I'm extending you this trust,
Yep.
if you want to appear by video conferencing at that time, because it'll be an arraignment, I don't want you to have to miss too much work. You can do that, okay?
Thank you. Thank you. I appreciate it.
and you're going to cooperate with the court. You're going to try and see about getting these matters resolved one way or another, even if it has to go to trial, all of those things.
Yes.
Okay. All right. So then we'll see you May 6th at 2 p.m. The video conferencing will be on your notice, and you should get that before you're able to leave the jail today. Okay.
Thank you so much, Your Honor. I
All
appreciate
right.
it.
Thank you, Mr. Locke.
You have a good day.
You too.
So, that's the end of his in custody appearance. And this judge is not typically the one to be so nice to defendants, but here she is being a sweetheart, probably because he played his violin of pity to her and pinky promised that he would make all of his court dates. Now, he didn't really say anything softedish, but all of that is about to change along with the judge's sympathetic attitude towards him.
Locke, is that you on the Samsung? You are muted, and I hit a button to ask you to unmute, and I'm now hit something to ask you to start your video. There you are. How are you doing today? Are you Mr. Locke? I don't know what's going on. I should be in there. I will hit a button again to ask you to unmute. There.
There we go. All right.
Are you
Hear me?
Mr. Locke? Ryan? Are you Ryan? Because I'm going to tell you, I need to understand who you are, because when I saw you at the last hearing, you were in custody and you were really, really tiny. So I need to be able to know, so I can put your picture of your face in my head to associate things. So I am speaking with Ryan Locke.
Object.
Sir, well, if this is the route it's going to go, and I think I've been very super fair to you, and with your bail and with all of those other things, if this is how it's going to go, then I will never allow you to be by Zoom again, and we can get a warrant and we can go that route. So if you want to cooperate and you want to participate and be nice to me as I am nice and respectful to you, we can go about it that way. How would you like to go about it?
I am trying to speak, and you are.
All right. So here's the thing. Nope, I'm letting you speak, and you want to speak and tell me all about your contract and how you're going to hold me responsible.
I'm not contracting anybody. I'm not saying any of that.
Well,
I'm just trying to speak my
so then tell me,
constitutional rights. That's it.
On your birth certificate, did your parents name you Ryan Locke? Yes or no? And I did grant you leniency, Mr. Locke, to appear by video. I have every right to never allow that to happen, ever. You understand that? Yes or no?
I'm asking you. Can I ask you a question?
Nope,
yes
not
no?
unless you answer my question. Do you understand what I said? Yes or no?
I object, and it sounds like the court is trying to get me into their jurisdiction.
All right, we will go on the record in the matter
of record?
26 CF 46, 26 TR 306, State of Wisconsin versus Ryan Locke. The state appears through District Attorney Kevin Schmidt in person. We have Emma Hanu appearing in person. Ryan Locke appears by video conferencing. He did call and ask permission of the court. He was being a cooperating individual and human being. However, he is failing to cooperate here today. Therefore, the court is stating on the record, at no time in the future, at any time whatsoever, Mr. Locke, may you appear by video conferencing or telephone. Your hearings will always be in person hearings. With regards to today, the court will quash the warrant. I don't have to do that, but I'll be nice and I'll quash the warrant. I'm resetting it to another date and time. Ms. Hanu has asked to withdraw. I usually ask for information and go into it. I'm not going to today, Ms. Hanu. You may be withdrawn. The court is going to reset this to another date and time. You were legally served. I have all of that information. So I do know that because you were in my custody and the court did give you leniency, did modify your bond, was trying to work with you, Mr. Locke. However, you refused to work with the court, and the court finds that to be completely disrespectful. Therefore, I am setting this for another date and time. Mr. Schmidt, is this a your case or a Filet case?
It is Assistant District Attorney Billard, Your Honor.
That's correct.
All right, so what I'm going to do here today is I am resetting it for May 27th in person at 2:45. May 27th, 2:45. We shall see you then. I strongly recommend that you call the public defender's office and you get another attorney appointed to you. I'm resetting it. Thank you very much. We are adjourned. Bye.
Well, that's one way to handle the dickweed. And I love how she hit him with the bye. Now, he did have another in-person hearing scheduled, but I guess his promises to show up to court are about as empty as his cranial cavity because he didn't appear and the judge is going to issue a warrant for his arrest. I guess he'll have to tell his new job that he may need an unexpected vacation sometime in the near future.
We'll go on the record in the matters 26 CF 46, 26 TR 306, State of Wisconsin versus Ryan Locke. The state appears through Assistant District Attorney Jose Villa in person. Mr. Locke fails to appear. This matter was scheduled for 2:45. It is 3:22. No appearance. Weather is great and you can drive and get here. There's no weather conditions at all. The court did have a hearing with him on May 21st, 2026, in which he appeared by video conferencing and was being combative and not complying with the court's process. The court ordered him to be here in person today at 2:45. He now fails to appear. What is the state requesting?
I would ask for a warrant, Your Honor.
The court will issue a warrant, $2,000 cash. Only judge may quash or posting of the cash. He will be provided a new date and time upon posting. The court is going to find him in default for 26 TR 306, and I will assess $200.50, 3 points off of his license for his failure to appear here today. We are adjourned. Oh, and the court will forfeit any cash previously posted pursuant to 969.13 of the Wisconsin statutes. Now we're adjourned.
All right, guys. That's the end of the video. It looks like the next time we're going to be seeing Mr. Locke is when he's locked up in the Burnett County Jail. Also, the sovereign citizen Karen from the first hearing will have a future appearance, and I'm sure that you don't want to miss that one. So, if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content.